Thank you very much indeed, Presiding Officer. Can I just say, my own experience says this is a very real issue, and it's not a particularly new issue. On one occasion, and it was 25 years ago, I had to fly from Vienna to San Francisco. So a contract could be signed. I had a very nice dinner with the director at Bank of America, who was the other party to the contract. I had a good night's sleep, and then I got a taxi back to the airport and flew to Glasgow. Total time in San Francisco, 14 hours, and most of it I was sleeping. So anything that helps you address that kind of, frankly, waste of time and money has pretty much got to be good news. Now, quite reasonably, Annabel Goldie raised the issue of different versions potentially being signed in the belief that they are the same version. And one of the things I did pursue during the committee stage of the bill with the Faculty of Advocates and with others is the issue of harnessing the power of mathematics and of electronics to inhibit that particular possibility. It's perfectly possible with a public algorithm and a public key to derive a hash which represents uniquely a particular document, a single dot, comma or letter changed in that document, resulting in a different key. So even if there are multiple copies, it is possible to know that these multiple copies are or are not identical by the application of appropriate technology. Now, this bill does not provide for that, but it did form part of the consideration of the bill. And I do hope that at some future date we're able to return to that subject and enable and require that to be used. I can.
Mike Mackenzie.
I seem to recollect that this is a similar mechanism that Mary, Queen of Scots, used, and yet one of our, or some of our letters were intercepted, and which that ultimately, I think, led to her demise. I wonder if you would care to comment on how effective this mechanism may be in reality.
Mr Stevenson, can we kind of keep it on legal writings?
I was referring, of course, Presiding Officer, to some of the Stage 1 matter that happened. I will simply respond to that by saying that, of course, you have to look at the work of Colville, who was Wellington's decryptor who broke the codes of Napoleon, and that's a much more significant thing. But that's beyond the scope of the debate, and perhaps cannot be fitted even in a generous 6 minutes. But I think the real point that did come up, and we did put to witnesses when we had them before our committee, was whether we should get to a position where we create the electronic infrastructure in Scotland so that a single copy can be held in one place and signing can be done electronically from dispersed geographic positions. There was some acceptance by witnesses that that was a good idea, but it was an idea they'd like to be the second jurisdiction to implement rather than the first. But there comes a time when you actually have to be bold and perhaps lift that one up. Sometimes we have to take for granted, if we can't understand, some of the mathematics that make these things possible. And in mathematics, there are P problems and NP problems. Essentially, NP problems are ones that can't be solved, and the encryptions we use these days are of that character. Now, the Faculty of Advocates and others in the legal profession are, not unreasonably, intensely small c conservative in their approach to things. They want to move in small steps, test, confirm that they work and provide the necessary security. But the danger with the process that the Law Commission undertakes, a rigorous examination, bringing fully developed proposals to Parliament, extremely helpful. But the danger is that all the contentious and difficult bits have been removed from proposals, and so you end up with something that is a bit of a lowest common denominator. And although this levels the playing field for Scotland, enables us to stand shoulder to shoulder with jurisdictions that allow counter-party operations, it doesn't take us ahead of the pack. And I think the witnesses agreed that there was scope for returning to this sometime in the future. we've got to, of course, if we decide to hold contracts in a central database, be confident that the confidentiality of that document is protected. Now, that raises a really difficult issue for governments of whatever complexion and wherever they may be based, because governments naturally have a difficulty with absolutely secure secrecy of information, of conversation, of communication. But in this case, you won't get commercial adoption unless that is present. So I think we will need to return, and again, the committee had this in evidence sessions, to looking at how we can provide that absolute security, but the legal framework that places such onerous responsibilities on those who use that kind of unbreakable encryption, unbreakable security, to respond to legal requests for access. Now, that's been done before. It's not particularly new, so I think that's a subject we need to come back to. Now, lawyers in the committee showed that they were willing to listen to the arguments, but that they would proceed slowly. And indeed, it was 25 years ago I was invited by the Faculty of Advocates to go and talk to them about whether they could introduce a secure email system. They listened politely, but decided they wouldn't do it. Now, Lewis MacDonald talked about the generation now, people under 30 seeing the electronic world. Well, it's actually 35 years since I sent my first email. So some things have been around an awful long time. And we need to think about, how rapidly things happen. My grandfather was born when Abraham Lincoln was president. My father was conceived before the Wright brothers flew, and I was 11 years old when the first transatlantic telephone cable came into operation. So every life takes us forward. We maybe have to speed things up a wee bit in the legal world to make sure that we keep up with the pack, make sure that we can actually draw new business to Scotland, not simply protect the business that we have. This is an excellent piece of legislation. I'm sure all members of the committee very much welcome the gracious comments that the presiding officer opened the debate with. I look forward to hearing what our convener has to say if called to speak, and I see his button pressed. And I'm very happy to support this particular bill and hope that the Delegated Powers and Law Reform Committee gets many more opportunities to engage in the overwhelming excitement that is legislation in the Scottish Parliament.